Just on the theme of trends that are happening in the space right now, have there been any important precedents set or novel approaches that are happening for IP litigation that it's worthwhile making a point about?
In terms of recent precedents, perhaps I would just mention two UK Supreme Court decisions, just focusing on the UK in particular for a moment. In the UK, the activist and Lilly case has been quite widely discussed now, and as the judgment has been out now for 3 years or so. A very interesting and important case which has introduced essentially the doctrine of equivalence into UK patent law. This means that the scope will not be defined solely by the wording and a purposive interpretation of that wording, but it will also extend to cover so-called immaterial variants. So small deviations from what is covered by the normal interpretation of the claim will also fall within that claim scope.
So at the benefit to the patent holder in that circumstance?
Absolutely. On the one side of the coin, absolutely. The other side of the coin is whether those immaterial variants, if present in the prior art, would be sufficient to invalidate the patent. And that is a question that has not yet been resolved.
Right.
So, of course, broadening the claim is good from a patent owner's perspective in terms of infringement, but of course you then broaden the target when it comes to it invalidating. But it's still unclear as to the extent to which that target really is broadening when the doctrine of equivalence is taken into account. So that's certainly been a fundamental change to our infringement law, and the consequences of that are still being felt and discussed in the courts.
So something for companies to be mindful of.
Certainly.
But I guess unclear about how that's going to play out as time moves forward.
That's right. And one for discussion, I would suggest with patent attorneys right at the outset. So considering the potential impact of equivalence, given that it is not currently clear the extent to which equivalence may be able to invalidate patents if they're present in the prior art.
And is that a UK specific law, or does that apply to other markets as well?
It also applies to other markets. The doctrine of equivalence is actually referred to in the European Patent Convention. So arguably the change in the law in the UK following the Lilly and activist case is actually to bring the UK into closer alignment to what is already in the European treaty. The doctrine of equivalence is already used in many European countries, but the extent to which it's used and exactly how it is applied, I refer to the immaterial variant test, for example, which is how it works in the UK, would obviously need to be considered on a national basis.
Understood.
So that was one interesting development, I would say, that's pretty fundamental in the UK. The other one is on second medical use claims, which is also has been the subject of a Supreme Court decision, the Warner-Lambert and activist case.
So this is pursuing alternative indications with a single product?
Correct, that's right. So these patents, they don't protect the product as such, they protect the product for use in treating a particular disease.
Right.
And they can be very useful because, particularly in circumstances where there is really only one disease for which the compound may be used, then it effectively amounts to an extension of the compound patent. So you could have a compound patent which lasts for 20 years plus any extensions. And then you may have a later expiring second medical use patent which protects use for treating the indicated disease. So very useful. The complication arises where a product can be used for treating several diseases, some of which may be subject to patent protection and some may not. And that is what was considered in the Warner-Lambert case. So if a company is producing a drug for generic purposes for the non-patented market, what steps does it need to take, if any, in order to prevent leakage into the patented market? And in that case, the question still hasn't been completely resolved, although it appears that the so-called outward presentation test may be sufficient. So providing the patented indications are carved out from the label and the label only refers to non-patented indications, it's thought that that ought to be sufficient in the UK in order to prevent patent infringement. However, there is still a possibility, given the mixed nature of the decision and the fact that it's obiter, so non-binding, and the fact that we don't have any first instance decisions that interpret that case. It's also possible, and the court left this open, that there could be a subjective intention element to the test. So, for example, if a generic company is making a large quantity of product for supplying into the non-patented market, but it knows, or perhaps ought to have known, that the drug would leak into the patented market, and perhaps if it didn't take any steps to prevent that, then that may also be sufficient to amount to patent infringement. As I say, at the moment, the courts have tried, I think, to give as much guidance as they can, and it appears that a carve-out from the label would be sufficient.
Right.
But again, given the state of the law, it is probably one that is worth discussing with a lawyer, because it may depend particularly on the size of the patented versus non-patented market and the volume of product that's intended to be produced, for example.
So for those companies pursuing repurposing strategies, it is making sure that the label of existing products is well understood and clear, but where there's room and where there isn't room. And then I suppose also pricing comes into effect as well. And so if you're pursuing a new product, or an existing product, I should say, for a new indication, then how that's priced will also have some implications.
Definitely, yes, that's right. There's no question that once a drug has been shown to be safe and effective for a particular disease, it becomes a very attractive target for use in treating other diseases, and those other uses are patentable. But the question of how effectively can those second medical use patents be monetized does become quite difficult. Certainly the question of whether and how to seek injunctive relief on the basis of those patents hasn't been fully explored, and that could raise again some quite interesting questions for the future.